This Honorable Court of Appeals of Tennessee is now in session.
Thank you, Mr. Hebner, and good morning, counsel. We're pleased that you could join Judge Bennett and Judge McBrayer and I for this virtual oral argument. Please understand that we will conduct the hearing in the same fashion as if all of us were in the Supreme Court room together. Each of you have 15 minutes, and the appellant has already reserved some of your time for your rebuttal. So unless there's any questions or announcements, we'll ask Mr. Hebner to call the case.
Roy Kelly et al. Versus Debre, Keranio, Medhanialem, Ethiopian, Orthodox, Tewahedo Church et al.
All right, please proceed.
Good morning, Your Honors. Justin Height for the plaintiffs and the appellants in this matter. I have reserved 3 minutes for my rebuttal.
Certainly.
Your Honors, this is a premises liability case involving life-altering injuries to a young boy, young Noah Kelly, who was significantly injured when he touched or came close to a down power line on the property at issue that was still live or charged. The property was owned and used by the appellee, who we have all referred to as Ethiopian Church. They are the owners of the property. The other defendant was St. Mary Church, who is not a part of this appeal because they were not a part of the summary judgment hearings related to this issue. St. Mary Church used 2 buildings on the property referred to as the Welch Road property that was owned and co-used by defendant Ethiopian Church. On its face, it may seem like a run-of-the-mill premises liability case, but a deeper dive into the facts reveals a legally complicated situation. I've looked extensively for similar cases in Tennessee and have asked other counsel with our office, Your Honors, to look at surrounding jurisdictions, but we could not find a case directly on point. And that's because in this situation that we have here, we have the Ethiopian Church, who is a co-user and a co-possessor of the property that they own, the Welch Road property. And the main issue on appeal is whether they owed a duty to young Noah Kelly. There are other issues that are addressed in the briefs that we may touch upon here in argument, Your Honors, but I submit they all stem from that main issue, whether or not defendant Ethiopian Church owed a duty. And constructive notice is certainly a main issue as well. But for the reasons I've set forth in my argument, and I'll set forth here this morning, I submit that they did have a duty, Your Honor. The Ethiopian Church stopped using the buildings for worship services several years before this incident. And St. Mary Church started using 2 buildings on the property for their worship services several years before this. The arrangement between Ethiopian Church and St. Mary Church was never put down in writing or formally memorialized, or nothing has been produced to evidence such. And I think that's important, Your Honor, for reasons I'll mention later. But as I've said earlier, there are several buildings on the property. One of the buildings housed deacons and priests of the Ethiopian Church, where they lived on a regular basis and had lived for a couple of decades at the time of the incident. The Ethiopian Church also used a building on the property for storage and to house refugees, and had been using those buildings for, again, almost several decades at the time of the incident. There were 2 other buildings that the Ethiopian Church allowed St. Mary Church to use for their church services. And then this was in 2012 when this arrangement began. And Your Honors, I submit that nothing was really put in writing because it wasn't a typical landlord-tenant or typical lease situation. And I think that is really important in this case, Your Honors. St. Mary Church, they didn't pay any rent. They both testified, the representatives of each testified that we didn't pay rent. There's not a rent situation, but we did make donations that varied in amount and that was month to month, but there was no penalty for late payment. There was no penalty for a reduced amount, and there was no amount set in writing. The defendant Ethiopian Church used the premises for the housing of their deacons and priests and for storage and for housing of refugees, and they could also use the premises whenever they wanted. And that obviously makes sense because they owned, co-used, and co-possessed the property. Ethiopian Church sent individuals and made sure that the property, entire property, mainly the outside areas, were taken care of, including mowing the grass, trimming limbs, providing major maintenance. They also took care of the water bill for the entire property, and they maintained general liability insurance on the entire property. To be fair, St. Mary's did take care of minor maintenance inside the two buildings that they used, and they paid for the electricity bill for the two buildings that it used.
What does the proof say about the last time Ethiopian Church used the two buildings that St. Mary's used?
The two buildings, I believe, was 2011, Your Honor. I believe it was, they ceased using it in 2011, the two buildings. St. Mary Church began using it in 2012.
Would the priest have families with them, and would their families be using the playground area where your client was shocked?
The record, there's nothing in the record to evidence that, Your Honors. The playground area is actually just an open grass area. The children played in that with footballs and soccer balls, but there was no playground equipment. It was just an open area of grass that was near the two buildings that St. Mary Church used. And to be candid, Your Honors, to get right to the point of this, and why I've zealously argued that there was a duty, I think my argument is much weaker if the injuries to the young Noah Kelly occurred inside the buildings that St. Mary Church used. As opposing counsel has submitted, they did have the keys to those two buildings. And they're the only ones who use the two buildings. They only use them on Saturdays and Sundays, but they're the only ones who use those two buildings on a quote unquote regular basis, so to speak. But it didn't occur inside the two buildings. It occurred outside in an open area. It was an area that was near the two buildings, but it was an open area. It was an open area that Ethiopian Church controlled and maintained on a regular basis and had been doing so for years. Because of the location of it, again, it's kind of in the corner. And let me be clear, as Mr. Smith pointed out in his brief, something happened when I printed my briefs, Your Honor, and the arrow to where the incident occurred was pointing to a building. And as Mr. Smith pointed out, it's actually a little north of that in his brief. I think it was just a formatting issue, but it's the north part of the picture submitted in the record in our briefs, just in that open area. And so that's again, the crux of the argument I submit, Your Honors, is that because it was outside on the property that was co-used and co-possessed and maintained by defendant Ethiopian Church, then they should have a duty, considering the totality of the circumstance and considering everything in the light most favorable to the plaintiffs, because we're here on a summary judgment and this is a question of law, Your Honors. Excuse me. There was a lot of argument related to constructive notice, Your Honors, and I know Your Honors are well aware of the law and the reasoning behind constructive notice. There was no actual notice. There's no dispute there. But we submitted an affidavit from an expert engineer who, based on numerous depositions from the Nashville Electric Service employees, who opined that the down power line was there for at least approximately 26 hours. And that's based on being there the morning before the date of the injury, which occurred about 2 or 3 p.m. in the afternoon on the following day. So from noon to noon, 24 hours plus an additional is 2 hours. So there's 26 hours.
Why does that serve as constructive notice?
Well, Your Honor, there's a heightened duty because there's children on the property, and both churches knew there was children on the property on Saturdays. And there's a heightened sense of duty, as submitted in our briefs in the case law, that when you have children coming on the property, you have a heightened duty to make sure that it is a safe premises, or to make sure that there are at least some policies and procedures in place to ensure that it is a safe premises. So when you have 26 hours and you know individuals are coming to your property on Saturday, there is an affirmative duty to make sure that that premises is safe.
So the church should have inspected the entirety of the property every Saturday before the Sunday services at St. Mary's?
Your Honor, either defendant Ethiopian Church or St. Mary's Church, which defendant Ethiopian Church could have ensured that they were doing, but they were not.
Well, who isn't the whole issue here? Who the who out of this is responsible? or whether the Ethiopian church at least is responsible, they didn't know. And you're saying they should inspect what? Every Saturday? I mean, every other Saturday? What is their duty here?
Well, there is duty to act reasonably under all the circumstances, Your Honor.
And what is that? In this
and I said-
circumstance, what's reasonable?
Sure. And I submit the Friday or the Saturday morning of when the children are coming onto the property to inspect the property. I've
Does
suggested,
the fact that St. Mary's knew and didn't tell the Ethiopian church, does that have any effect on this?
I think it's something to consider, Your Honor. And I don't think St. Mary Church knew until it occurred. They knew the power was out several hours before the incident occurred. And it's our position that if someone would have went out there,
St. Mary's knew that, right? Not Ethiopian church.
that is correct, Your Honor. The record shows the Ethiopian church never knew about the incident until after it had occurred. And so, Your Honor, similar to many case law out there, when you know individuals are coming onto your property, such as a department store, there's many cases of a Kroger, a Publix, and whatnot. In Shoney's, when you have people coming on your property and you know it, then you have a duty.
So this line obviously that went down supplied electricity to at least one of the buildings that St. Mary's used.
Yes, Your Honor.
Did it supply any electricity to the buildings the Ethiopian church used?
I think the record shows that it did not, Your Honor. I'm
did
not
not.
100%, but I'm pretty sure it did not.
So the Ethiopian church had no reason to know by way of power outage that this had happened.
That is correct. By reason of power outage, no, sir, Your Honor.
Okay.
Mr. Hyatt, let me ask you too about the timing of the poll coming down. It looks like your expert's affidavit says two different things about when the poll came down. In his affidavit, David, in paragraph 7, he says, for the reasons cited above and in light of my years of experience, education, and training, I conclude that the down power line likely occurred on July 14, 2016. And then 2 paragraphs later, he says, for the reasons cited above and in light of my years of experience, education, training, and in terms of more likely than not, the down power line occurred in the morning of July 15, 2016. Mm-hmm. So I'm not sure which date to use. You seem to be arguing it's the latter of the two dates.
Yes, Your Honor. Your Honor, this is based on, talking with them. Because the reports for NES run the morning of the day before, then that's when we knew it was lost. So it's my understanding, he says, likely happened the day before. But in terms of more likely than not, what I can testify to is it was down no later than the morning of the day before. That's where I've gotten the 26 hours. It's possible that it occurred the day before that, but not in terms of more likely than not. It was down the morning of the day before.
Thank you, Mr. Hite. We'll hear from you on rebuttal. Mr. Smith.
Thank you, Your Honor. May it please the court, Warren Smith for the defendant, Ethiopian Church. This is indeed a case of constructive notice and of the co-possession. Is our position this was not a co-possession at all, and there was no constructive notice, thus no duty. I think it would be helpful to explain the locations of these buildings with respect to the other buildings. Initially, when the Ethiopian church bought the property, there were two addresses. There was 214 and 224. They later combined them together, I'm assuming for tax purposes and whatnot, as to 214. But the church that the Ethiopian church started using, and it's there's a Google map on in our statement of facts at Roman numeral 14. It shows the church building or the sanctuary is on the left-hand side. Then the building that they refer to as the fellowship hall or the Sunday school building is perpendicular. And this area between the two is bordered by woods And that's essentially the side yard of the church and the side yard of the Sunday school building or the fellowship building. And that is where the power pole was located, and that is where, where the incident occurred. The other buildings that have been referred to, the priest buildings and the deacon's building, these are located down below across the property on the right-hand border. And then the storage units are on the bottom border. All of those are separated in the center by a gravel parking lot. I think it's important to note that the church building and the Sunday school building and the playground are all contiguous. They all touch one another. They're all one unit. The priest housing does not touch that unit. The storage building does not touch that unit. So there's a separate entity there. When
What do you mean a separate entity there? You mean a separate building?
No, I'm talking about the church and the Sunday school room building and the playground is a group among itself, a contiguous unit, and that's what was rented. In other
So
words,
were there priests on site though when this incident occurred?
not that the record shows, Your Honor, and that building is not, as it sounds like it may be understood, a dormitory for priests. This is a visiting priest and visiting deacon's house. So when there are visiting priests or visiting deacons, there is a place for them to stay. And we don't know from the record whether or not there was anybody staying at that time or not. The agreement that was reached back in 2012 was for the St. Mary's Church to rent, use as a church, the sanctuary building, the church building, and the Sunday school building. And I would suggest both the side yards of each, which comprised what was later known as the playground. This area, as Mr. Height said, was not a playground where there were slides, swings, etc. It was just the two side yards of the Sunday school building and the church that converge, and that it was bounded by woods on each side. So they essentially had a corral for the children where they could go outside and play and be pinned up by buildings and woods, and with only one way out.
Children's corral.
That's how I would refer to it.
Okay.
The agreement that they had did indeed provide everything that's necessary for a contract or an agreement. They had terms, they had consideration, whether they called it rent or they called it contributions. Nonetheless, they paid a certain amount each month for the use of the church and the Sunday school room.
A certain amount, or did it vary from month to month? I thought Mr. Height said the donations, or whatever you wish to call it, varied from month to month.
It varied depending upon what they could pay at that month. I believe the record reflects they were paying $1,000 or trying to pay $1,000, but in the event they came short one month, they would make it up the following month. The agreement is important from the standpoint of the terms of the responsibilities. The Ethiopian church had been mowing the lawn, taking care of the lawn since they had it from 1991, I believe. They agreed to continue the lawn work, and they would do maintenance to the major items of the buildings and the structures, and they'd provide the water. St. Mary's agreed they would do minor repairs, day-to-day upkeep, and that they would provide the electricity. With respect to the insurance that Mr. Hyatt has discussed, St. Mary's was to provide insurance, but they, at some point in time, let it lapse and did not have it at the time. The right of control is something that's, I think, determined.
What kind of insurance was St. Mary's supposed to have?
They were supposed to have liability insurance. I believe Mr. Seged's testimony was to protect themselves, which I would take to be liability insurance. Of course, Ethiopian Church provided the standard fire, extended coverage, and liability insurance as the owner of the property.
So the Ethiopian church had liability insurance over on the property?
To the extent there would be liability, assigned to them. Of course, there was a distinction between the church and the Sunday school room that they had rented and leased to St. Mary's. They still had the deacon's housing and the storage part in the general area.
Excuse me, are you saying that the Ethiopian church did not have liability insurance over the two buildings that St. Mary's rented?
To the extent that there would be liability determined against the Ethiopian church. Yes,
Yeah.
The coverage was general for the whole property, but it was not liability insurance for everybody. It was liability insurance as to the Ethiopian.
I understand that, but they did have liability insurance over the entire property.
Correct.
As to the Ethiopian church.
Correct.
Okay, thank you.
Okay. With respect to the right of control, which is determinative in this case, I believe, it's important to note, and these are undisputed facts in the record. It's one thing I wanted to touch on, that these arguments we're making or I'm making are undisputed facts that you can find in the record and documented. They're not conclusory statements based on just general terms. St. Mary's retained the keys to the sanctuary and the fellowship building. They had the keys, and Ethiopian Church did not, which is consistent with sole possession on the part of St. Mary's. St. Mary's had to give permission or allow access to the Ethiopian Church in the event there were major repairs necessary. And it's undisputed facts that if there was a problem inside the church or inside the Sunday school building, the Ethiopian Church had to contact the St. Mary's Church to get authority and schedule a time for them to let them in. St. Mary's was responsible for the day-to-day operation of its church. There was nothing connected between the Ethiopian Church and St. Mary's from the standpoint of operation of the church. St. Mary's wasn't a mission or a spin-off of the Ethiopian Church. It was totally separate and complete.
St. Mary's paid the electric bill, right?
And St. Mary's paid the electric bill. And the electric bill was in the name of St. Mary's. Excuse me. The appellants have stated that the Ethiopian Church could use the property at any time it wanted to, and that's just not consistent with the facts and evidence. There's no testimony with respect to the Ethiopian Church being able to use the church at any time it wanted to. The one reference made was when asked, could the Ethiopian church use the sanctuary, and Mr. Tesfaye, the chairman of the board, said, of course, but then in a further reading, you would find that he was saying, of course, that anyone that wanted to use their sanctuary would be allowed to, and that he went further to say, however, with their religion, the sanctuary had to be sanctified, and that required a priest being present. And so you still have the indicia of having to get permission from St. Mary's. The appellants also argued that this playground was a common area. It was not. It was a piece of yard between the two buildings used by St. Mary's. There were no other children present. There were no other people that used this. The storage facility obviously wouldn't use it, and the visiting deacons, I would suggest, would not use it. The area got the name playground by virtue of St. Mary's. They're the ones started using it as a playground. There was no evidence in the record at all that the play area was set aside in their agreement to be retained by the landlord or by the Ethiopian church. It was not a common area. The only thing the Ethiopian church did was mow it. The court correctly held that the fact that the Ethiopian church was in possession or control of a place to worship in the playground area where these events happened didn't put them in possession, that they were not in possession. With respect to the accident or the incident, there's no prior evidence of any issues with the power line, no prior evidence of any issues with trees, rotted trees, etc. Nashville Electric Service arborist has testified that the tree that fell was indeed a live tree, that there was no indication that the tree would fall, and he didn't know why the tree failed, to use his words. The fact that it was down using the plaintiff's experts, I would suggest, guess of 26 hours is not determinative, because, as Your Honor stated before, the Ethiopian church would have to come by and visit the place every day somebody was present if there was the duty that the plaintiff puts on them. That's not reasonable.
Who actually performed the lawn mowing for that playground area? I know that your client paid for it, but who did they contract that out, or did someone at St. Mary's mow it and then get reimbursed? How did that work?
Your Honor, I do not believe it was someone at St. Mary's, but I think some individual was being paid. As to who he was, I don't know.
All right. Thank you, Mr. Smith. Mr. Hike, rebuttal.
Sure. Just briefly, Your Honors. I wrote down this, and I know opposing counsel is more knowledgeable or intimately aware of some things that might not have come out and are on the record, but I think that the record showed that it was the deacons and priests of Ethiopian church that lived there on a regular basis and had been. And it may also house some visiting deacons and priests, but I was pretty sure the record showed that it was their own deacons and priests that lived there on a daily basis. In Judge Bennett, I think Mr. Smith may have cleared it up for you, but I wasn't sure in your questioning. St. Mary Church did not have any insurance at all at the time of the incident. I think Mr. Smith may have addressed yours, but I wrote that down just in case. The Ethiopian church did have general liability insurance for Ethiopian church. And outside of the building, there was testimony, and it's in the record, that the pole, which ended up snapping, was in a deteriorating condition and had been in a deteriorating condition for several years. The testimony from the St. Mary's representative, I believe, said that, but that is in the record as well, Your Honor. Mr. Smith mentioned this. Again, he mentioned the keys into the buildings, and I think that's the difference, Your Honors, as I said earlier, that inside the buildings, arguably, St. Mary's had the control and possession, but I submit that's the only control and possession they had was of the buildings that they used, Your Honor. Now,
So you're saying the Ethiopian church always had ability to walk around the outside of the grounds where the power line was down.
Right, because it's their property, again, which they use and co-possess on a daily basis. But now the two buildings, the record is clear that St. Mary had the keys to those buildings, and if needed, the Ethiopian church would have to ask St. Mary to get into the buildings, since they did give them what amounts to exclusive control of those two buildings. I think that's the difference, Your Honor, and I may be wrong. I've been wrong before, and I'm sure I'll be wrong again. But I ask the court to provide some guidance maybe for future cases in a co-reference or co-use, co-possession case, because do we need to make sure lines are drawn? Say, hey, do you ever use this part past this line of chalk? Or, in pictures that we use for depositions on a regular basis, it's hard to differentiate exactly where do you use and do you not use. For apartments, that's kind of it's a lot easier when you're a landlord and tenant and you have any possession of a property and you allow them to use it. We have plenty of case law, but when you're also on the property, whether it be in a duplex situation, I guess could be very similar, but there's just not great case law that is fact intensive and that applies directly to this case. So thank you, Your Honors, for your time. I greatly appreciate it.
All right. Thank you, Mr. Height and Mr. Smith, for your arguments. We will take this matter under advisement. Mr. Hibner.
This honorable court is now in recess until 1 p.m.